So I have an important update in the suppressor freedom lawsuit, which aims to remove state bans on the purchase and possession of suppressors. So let's break down what is happening. Now, before we jump into this video, I want to thank the sponsor of this video, which is Montana Knife Company. MKC was founded by master bladesmith Josh Smith, who started making knives at just 11 years old and became one of only 150 master bladesmiths in the world at just the age of 19. Every MKC knife is made in the state of Montana by experts, and they're made for hard use. These are not just, your run-of-the-mill knives. These are knives made by quality experts, and they're made to last the test of time. One of their most popular blades is the Speed Goat, and its little brother, actually the Magna Cut Mini Speed Goat, is very popular as well. The Mini Speed Goat is lighter, thinner, and just as tough, and it's perfect for everyday carry and for also non-hunting uses. The Mini Speed Goat has a blade of just under 3 inches, which makes it legal to open carry in most US cities and states, making it kind of one of the go-to blades for everyday carry and just kind of your daily routines. Now, one of the things with all MKC knives is they sell out really fast, so I highly recommend that you sign up for their newsletter. I will link that down below in the details section and also in the pinned comment, so you get updates on all availability of all of their knives. And whenever they release exclusive knives and they have these, exclusive releases, you will get notified first before everybody else. Anyone who's on the newsletter, you'll get notified and you'll have a chance to pick these up because, again, they sell out almost immediately. So again, thank you to Montana Knife Company for sponsoring this channel. I cannot recommend them enough, and I highly recommend that you sign up for the newsletter linked down below to get notified of all releases. As I mentioned in the intro, in this video, I have a big update for you guys in one of the lawsuits, which aims to remove a statewide ban on the purchase and possession of suppressors. The case we're going to be talking about in this video is called Morse versus Raoul. Now, this is a lawsuit filed in a federal district court in the state of Illinois, and the aim here is to remove the state of Illinois' ban on the purchase and possession of suppressors. This lawsuit could kind of be one of the first ones in the nation, which actually finds that a state's outright ban on NFA items like suppressors is in fact unconstitutional. This could also impact other state challenges on suppressors and SBRs because there's other states which restrict NFA items. And right now there's another lawsuit going on in the state of California, which is also challenging the state's ban on suppressors. Now, currently in this case, the state of Illinois is trying to have the case completely thrown out by arguing that suppressors are not arms and therefore not protected by the text of the Second Amendment. The state of Illinois is currently requesting that the judge here in the case grant a judgment on the pleadings in the state's favor and essentially throw the entire case out right here and now. This case was temporarily put on hold, but now the state of Illinois has asked the court to take notice of a Fifth Circuit decision which upheld suppressors as non-arms and not protected by the Second Amendment, and now this case is moving forward towards an actual hearing. The judge in this case has set a hearing in this case, and it's going to take place next week, next Wednesday. So again, this is a very important challenge that we need to talk about. The court will now decide whether the suppressor challenge will be thrown out early or whether it will proceed forward on the merits, and they will review the Second Amendment arguments in this challenge. Now, in this case, the plaintiffs argue that suppressors are not dangerous and unusual items, and therefore the mere ownership of suppressors cannot constitute the ownership of dangerous and unusual items. Instead, they argue these items are common arms owned by law-abiding Americans for lawful purposes like self-defense. Now, the state of Illinois recently filed a motion for judgment on the pleadings to try and have this case thrown out before it even really begins. In their motion, the state argues that the Second Amendment protects only the right of the people to keep and bear arms. Silencers are not weapons. They are not used for self-defense, and they are not necessary for the effective use of a firearm. So they are not arms within the meaning of the constitutional text, and therefore plaintiffs cannot prevail on their Second Amendment claim. They go on to argue that while an instrument need not have existed at the time of the founding to fall within the amendment's ambit, it still must fit the founding era definition of an arm. But a silencer is not itself used to cast at or strike another. It does not contain, feed, or project ammunition, and it does not serve any intrinsic self-defense purpose. And while some people find silencers useful, they are not so critical to firearms ownership that firearms cannot be used effectively without them. Silencers are therefore not arms within the original meaning of the constitutional text. They also state that silencers do not satisfy this definition of arms because a silencer is a firearm accessory. It's not a weapon in itself, nor is it an armor of defense or offense. The state's primary argument in this challenge is that a suppressor cannot be considered an arm under the Second Amendment because it's not an actual firearm that shoots a projectile, and it's not 100% necessary for a firearm like a rifle to function. They argue that suppressors are simply accessories and therefore not protected. Now, of course, that contradicts the fact that under the federal laws and the NFA, they are treated as actual firearms, as actual weapons in their own right. You have to do a background check, NFA items and taxes and registration and all that. But here the state says that despite all of that, even how the federal law treats them, they are not a weapon within their own right. Now, the hearing on the motion was temporarily stayed by the judge here in this case because he believed that the Illinois rifle ban decision could impact the outcome of this suppressor case. The judge in this case decided to put it on hold and see essentially what the Seventh Circuit would do in the recent PICA challenges and also what the lower court judge, Judge McGlynn, would do in the PICA challenge that he was reviewing. The judge here in the suppressor case believed that maybe the PICA challenge and some of those restrictions which were being reviewed would impact this case because, those dealt with rifles and certain characteristics like threaded barrels and flash suppressors. So the judge here believed that maybe some of that decision and some of that analysis could impact what happens with suppressors. Now, as we know, recently Judge McGlynn issued a decision striking down PICA as unconstitutional, and now that has been elevated to the Seventh Circuit. Now, because of that recent decision, the plaintiffs here in the suppressor case submitted that win as support for why the motion for judgment on the pleadings in the suppressor case should be denied and the suppressor ban challenge should be allowed to move forward. Now, in response to that, the state of Illinois has now submitted their own supplemental notice of a related case that came out of the Fifth Circuit in a case called U.S. versus Peterson. The Peterson case involves an individual who had a gun store within his own home, and it was raided by the ATF. Now, during that raid, a single solvent trap was found within his home. It was not registered or serialized, and because of that, he was charged as, essentially a criminal charge for possessing an item that was not registered under the NFA. Mr. Peterson and his attorney tried to get that charge thrown out using a motion to dismiss, arguing that the NFA violated the Second Amendment. That motion was denied, but now that's been elevated to the Fifth Circuit, and the Fifth Circuit is going to review that. When that case was elevated to the Fifth Circuit, a Fifth Circuit 3-judge panel found that suppressors are not arms because they do not trigger 2A protections, again, because they're simply accessories. They called them accoutrements, and again, they were not necessary for the function of a firearm. That, again, has been elevated now to the Fifth Circuit en banc panel, and there's a lot of in-between going on right now because the DOJ is deciding what they want to do with this because that was challenged by the Biden administration. Of course, that's changed over now, so Pam Bondi and the DOJ are trying to decide how they want to handle that lawsuit. However, Illinois is trying to use that case, and in their recent motion, they state that Peterson holds that suppressors do not trigger Second Amendment protection, thus rejecting the same theory pressed by the plaintiffs in these consolidated actions. As the Fifth Circuit explains, whether suppressors constitute arms is an issue of first impression in our circuit. Insofar as we can tell, every court to have addressed it has decided the question in the negative. A suppressor by itself is not a weapon. Without being attached to a firearm, it would not be of much use for self-defense. Instead, we agree with the 10th Circuit that a suppressor is a firearm accessory, not a weapon. And while possession of a firearm themselves is covered by the plain text of the Second Amendment, possession of a firearm accessory is not. As the government aptly explains, an operable firearm will work perfectly well without a suppressor, but a suppressor will not transform an inoperable firearm into an operable one. Moreover, it can hardly be said that suppressors regulations has rendered the right to bear arms meaningless. The use of a suppressor, as we noted above, is not necessary to the use of a firearm, so it's not protected by the plain text of the Second Amendment. Again, that decision by the Fifth Circuit is likely going to be reheard by the Fifth Circuit en banc panel, but the state of Illinois is trying to use that decision as support for why this suppressor restriction challenge here in the federal district court in Illinois should also be thrown out. Well, now this Illinois suppressor challenge will be heard in front of this court next Wednesday. So next week, a critical suppressor challenge will be heard in this court. The judge is setting the hearing on the motion for judgment on the pleadings. It's going to happen again next Wednesday. And Judge David Dungan is the judge here who's going to be reviewing this. And now he will decide whether he will follow suit with some of these other circuit courts, like the Fifth Circuit and others, who found that suppressors are not protected items. Or is he going to at least let this case proceed forward on the Second Amendment arguments and essentially hear out the plaintiffs here and see what some of the challenges and arguments they're going to make when it comes to the Second Amendment? So this is something we're going to be watching closely, and I'm very interested to see, how the oral arguments play out. You can kind of gather a lot based on some of the questions that the judge asks, and also some of the arguments that are presented. It's going to be interesting to see, how Illinois argues this, and also how the plaintiffs argue this, and how they're going to try to get around some of the Fifth Circuit and 10th Circuit, precedent that's out there. But ultimately, this is one of those things that's going to be elevated eventually to a higher court level. We need these cases to proceed forward, and this is one of those really critical challenges because, again, it goes against a statewide ban on NFA items that restricts individuals within a certain state from being able to even purchase or possess these items. So we're going to get an answer on whether or not the Illinois suppressor ban challenge will be able to move forward, and if it's thrown out based on the judgment on the pleadings, of course, that's kind of a final merits decision that will then be elevated to the next level. So as we get more information, as this develops at the hearing, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.